Hello, everyone. Welcome to the SIAC webinar on post-COVID, the future of international arbitration in Malaysia. My name is Angela. I'm Associate Counsel with SIAC. Thank you for joining us on our discussion today. We have actually quite a lot of participants with us. Majority of the registrants are based in Singapore, and we have friends from the US, Malaysia, India, Australia, Brunei, China, and just to name a few. Let's move on to our panelists. Our distinguished panel today hail from Malaysia and Singapore, two very closely linked countries in many respects. So as a lot of our Malaysian users have international arbitrations that are seated in either Singapore or Malaysia, I'm actually very excited to hear the point of view from both jurisdictions. Now let me give a brief introduction of the panelists. Let's start with Mr. Lim Tak San. Tak San is a partner in Tree & Company Chiang & Arif, and his primary focus is in commercial and corporate litigation and arbitration. I have market sources that commended that Tak San is sharp and strong in terms of strategy, so I'm looking forward to some insights from him today. Next, we have Mr. Chong Boon Leong. He is a partner in Allen & Glahier of Singapore and also in Rama Lim and Partners in KL. Boon Leong is an experienced international arbitration practitioner in Southeast Asia in the past 15 years. And his practice focus is on commercial and corporate disputes, complex power and energy, and infrastructure disputes. The advantage of Boon Leong today is that he's taught to both the Singapore bar and the Malaysian bar. So looking forward to his insights as well. Now, next, we have Mr. Tan Liam Bing, who is the director of LB Law LLC. Liam Bing is a qualified engineer, and he's a highly experienced lawyer in building and construction industry. And he is certainly known for his contentious and non-contentious legal work in Singapore and in Malaysia. And now last, but certainly not the least, Ms. Sitpa Savaratnam, who is a consultant of Mrs. Tommy Thomas in KL. Sitpa is no stranger to SIAC. She's a seasoned international arbitrator with 28 years of experience in dispute resolution as a counsel, and she specializes in shipping and maritime law and international trade. A very warm welcome to our panelists. Thank you for joining us. So in today's session, we would like to be forward-thinking. As Malaysia is slowly easing out of the MTO, our minds are now turned toward what will happen as businesses return to work. Now, there is great anticipation that there will be an increase in disputes. So it's perhaps timely to explore the changes that COVID has brought about in the way cases are being conducted, the impact of such changes to international arbitration, and what Malaysian users should be expecting from the process moving forward. Now, the panelists today have a very difficult job, which is to crystal ball gaze into the future, to give us a glimpse of what users of international arbitration should be aware of when it comes to dispute they have currently. So now, before I begin diving into the questions, there are some housekeeping matters. Participants can pose questions using the Q&A button at the bottom of your screen. But due to limited time, the panel probably will not be able to address all the questions, but we will try to address a few as we go along or towards the end, depending on how long the discussion will take. I would also like to go on the record for the sake of our panelists here today that this webinar is held under the Chatham House rule. That means those who are listening in, you are free to use the information that you receive, but you shouldn't reveal the identity or affiliation of the speaker. That means just don't quote them outside of this webinar. So let's start the session. My first question is actually to Boon Leong. Now, COVID has affected businesses on a global scale, and no one is spared. So with businesses being strapped on cash and having to scale down on expenses, do you foresee a decline in interest towards international arbitration as compared to, let's say, mediation or informal negotiations, since they can be done in-house? What are the trends now?
Thank you, Angela, and thank you for the kind comments earlier. Well, first off, I'd like to say that, I think everyone is quite acutely aware of how bad the scenario is out there in terms of commercial activities and business. However, if one would take a step back, one would realize that this little calamity that's brought on upon us has not really been in place for that long. It's a scan 2, 3 to 4 months at the most. And I would like to say right from the outset that in these short period of 3 to 4 months, I am not in a position basically to identify any specific trends in relation to international arbitration or mediation, which is directly brought about by COVID-19. I think it's much too early. We'll probably have to wait a little longer. And why is it that we have to wait? It's because I think that this little downturn that we have is not our garden variety downturn that we have cyclically. This is largely unprecedented, and it depends on where one reads. Some of the doomsayers, of course, will say that the sky has fallen. So I think that in terms of trending, we will probably have to wait some months, if not a year or so, before we can get an idea of whether there is or there isn't a trend amongst users to move to mediation or informal negotiation as compared to international arbitration. But from what we can see in Malaysia anyway, it's not that different, I think, from other jurisdictions. Perhaps the increase in mediation and informal negotiations that we now see may not be as marked as what you would experience in some of the more developed jurisdictions. It may well be that we need a bit more time to get round to preferring mediation, but the entire question, I think, is predicated on this supposition that somehow mediation or informal negotiation will eat into the market of international arbitration. That's actually not a view that I share, because I take the position that the market for international arbitration, mediation and informal negotiations are pretty distinct. And yes, while mediation and informal negotiation may help some of the cases avoid international arbitration, I don't think that that will bring about a decline in interest, simply because I think arbitration, as we have seen in the past 2 decades, has this continued development in terms of interest and utility to the commercial people out there who have disputes. So in short, I do not foresee a decline in interest towards international arbitration, because there will always be those cases which, despite the best efforts of parties and mediators, they would not be able to find an acceptable solution to everybody's agreement. And those cases will always be there. And so long as commercial activity, certainly in this region, does not nosedive, then there should not be a decline. But then again, even if the economy were to take a nosedive, you may expect an artificial level of interest in international arbitration in the short term. And that's probably for the parties with transactions and disputes in acute stages where they can't help it, they've got to get that done. But we would not expect that kind of interest to be sustainable if the economy continues to tank, as it were.
Daksan, any views to add?
Absolutely. I agree 100%. First of all, there is I think what's happening here is unprecedented. I think we lived through the recession in 88, 97 to 98. Then the last tanking in 2007, and right now the current situation, and I think this is possibly the most severe that I've seen. The impact on dispute resolution in the last 3 cycles, at least from what I remember, was not that hard. In the sense that there will be disputes, and there will always be a need for people to resolve those disputes. The issue right now, when it comes to arbitration, is that I think a lot more investment has been put into infrastructure so that we can do things remotely. So when it comes to international arbitration, we have something put in place that allows for remote hearings, and there's flexibility that is not otherwise afforded in courts. The courts are only just moving there. So yes, I do foresee that there is potential, because I think as commercial practitioners, we are more flexible in that area.
Okay, that's heartening to know. Of course, I think it remains to be seen how the economy develops, as Boon Leong mentioned as well.
Yes.
Liang Bing, what
Yes.
do you think, having in mind what the previous panelists have mentioned, do you think the consideration of whether to commence international arbitration are now different? Are there any new considerations that parties should be thinking about?
Yeah, the pandemic has obviously adversely affected economies all over the world. Yeah, and the impact will definitely be felt in the years to come. Right? Malaysia and Singapore are no exception to this adverse impact. Businesses will no doubt also be adversely affected, such that their health, their financial health and well-being will obviously be affected one way or the other. Right? So, whilst there are no new different ways of considering how to commence an arbitration, or even there are certainly certain factors will now come into the forefront as a result of this pandemic, which have caused financial health of companies to deteriorate. Right? So before one goes into an arbitration, right, one must think about how the opponent will stifle you when you commence an arbitration. Right? One of the things that can be used to stifle an arbitration commenced by a claimant is to make an application for security for costs. Right? So if, for example, you are affected financially, such that the other party can run the argument that you cannot pay the costs if they are successful in their defense, then that may just prompt them to take an application for security for costs. Right? So if you are in a state where your health has deteriorated, right, you want to consider very carefully whether you want to launch the action where you potentially open yourself for all these applications. Right? And if you do decide to go ahead because you can sell some of the assets to fund the arbitration, right, you must also think carefully, because the other party may just say that, especially when they have a counterclaim, they may just say that, you're trying to dissipate your assets and go and take a court injunction to stop you from, selling your assets, right? So yes, these are not new considerations. This has always been there, but because of the pandemic, I think it will come to the forefront. And also, right, one of the considerations that will come about as a result of this pandemic is your ability to enforce whatever award or judgment that you may procure out of arbitration, right? So if the other company is already in dire straits because of pandemic, right, it may just turn you away from wanting to commence an arbitration.
Yeah, thanks, Liang Bing. Cost is definitely a very key issue here, and that leads me to the discussion about third-party funders. Maybe I'll go back to Boon Leong. Based on your experience collaborating with third-party funders, is it easier or harder now to get funding from third-party funders for your arbitration?
Okay, in keeping with the topic, of course, COVID-19, I think most industry stakeholders today would expect that in the future, dispute proceedings will become more document-based. So everyone is sort of anticipating a slow move, perhaps a lot closer to the civil system where disputes are dealt with only on documents. Now, I raise that because, as you would expect from third-party funders, one of the very critical exercises that they undertake for purposes of funding would be to assess the strength of the merits of the claim that is sought to be funded. Now, in our adversarial system, the job is a bit more complicated because you will have witnesses, witness performance, the demeanor of witnesses. But if it's all largely going to be dealt with through documents, then it would actually allow, I believe, the third-party funders to have a better grip on the strength of the claim that is being sought to be funded. And that, I think, will make it, if you want to use the word easier, to convince a third-party funder that your claim is commercially sensible for them to fund. So that's one aspect of it. The other aspect, of course, is that certainly in Singapore, with the advent of third-party funding, there was a lot of interest. There was a hive of activity where you have the third-party funders essentially meeting with the arbitration practitioners. There was a lot of interest, a lot of activity. That activity is still going on, but somewhat reduced. But what we have seen today is that, as an example, the third-party funders used basically to focus on single claims for funding. But right now, I do believe that some of them are already considering multiple claims, cluster claims, all right, and basically even prepared to negotiate in terms of the minimum sum for the claims before they're prepared to fund. So in that sense, with all these developments, I would say that, for want of a better word, is it easier now to get funding? I would say that the scope for getting funding has basically increased. And with COVID, changes brought to the disputes proceedings, hopefully that would help basically to get third-party funders a bit more aggressive in terms of funding.
Okay, that's interesting. Sorry, continue, please.
Oh, the only thing is that you said something about being a member of the bar in both Malaysia and Singapore. Yes, this is a Malaysian webinar, but we're talking about third-party funding, which is of course not available in Malaysia. And it is still pretty much viewed as a public policy no-no. And I think that the last attempt was, I think, in early 2018, when there were very strong lobbying to get third-party funding into the law. That did not get through. And I say that because for us Malaysian practitioners, in the event that we were to basically represent client, act in an arbitration in a fund-friendly jurisdiction, and if our clients were to obtain a funded award in that jurisdiction, which is fund-friendly, there is a long-suffering issue of whether that funded award can be enforced in Malaysia before the Malaysia courts when third-party funding, Shampati maintenance remains illegal, as it were. But there are no cases on this. The jury is still pretty much out there. And I think that if you were to take examples from other jurisdictions, you will find that what has happened is that there has been a sort of a move to basically conclude that such an award, a funded award, should be enforceable despite potential public policy grounds. Most industry stakeholders would classify the risk as low, but at the same time, none are prepared to say that you can discount that risk. So that is something which I think that as a Malaysian practitioner, if we happen to work on a funded proceedings and we get an award, we should be very careful to first assess whether the Malaysian courts will take the line to enforce that award.
Is that a view you share as well, Taksan? Anything further to add?
Yes, I do share that view. Now, the Malaysian courts have steadily rolled back arguments of public policy for over the past 40 years. But we cannot, there is still a fair amount of resistance when it comes to what third-party funding implies. While I think Boon Leong and I will take a more robust view in coming to the conclusion that an award in Malaysia will be enforced in any event. There is always that possibility that an argument will be raised that a party without any legitimate interest in the litigation has somehow promoted that litigation, particularly in view of the fact that our practice and etiquette rules do also say that no strife and litigation should be stirred up. So there is that window for argument. I think Boon Leong, a bit subject to what Boon Leong says. Okay, the window for such arguments, I think, are closing, but it's still there.
Okay. That's something, that's an option that parties can consider, but they have to be quite careful about that then. Now, I would say to SIPA right now then, well, now it's, well, we can consider somewhat post-COVID, somewhat, fingers crossed. We see unique issues that probably would come out from the pandemic and its effects. So do you, SIPA, see more cases arising from the force majeure clauses and frustration doctrine as predicted by many law firms and their write-ups?
Thanks, Angela. Yes, certainly I think we will see more cases that raise the issue of force majeure and frustration. And it's certainly because any allegation of non-performance in the first half of this year would have as a central issue COVID, or the measures taken to spread the control the spread of COVID, whether it's the quarantine, whether it is the stay-at-home order that prevents someone from bringing in contractors to finish performance, or it's business closure, or disruption in supply chain. So if this be the span of the reasons that could cause the non-performance, and in international shipping in particular, international trade and shipping, we have standard form contracts that make reference to certain circumstances such as an epidemic, pandemic, an outbreak of disease, act of God, act of government, or any reason beyond the control of the parties, and if the clauses provide for certain consequences of one of those events occurring, then certainly a party who is alleged to be in default will run force majeure and a frustration as a defense to excuse himself for the failure to perform. Now, I must make the distinction that force majeure is a creature of contract, and therefore we look to the contract for it, and its ambit of application depends on the width and breadth of the precise wording. But what would happen, I think, is that most parties will dovetail that with an alternative plea in frustration to say that that's provided by law. It doesn't need to be found in the contract, and that the contract has become impossible to perform through no fault of the promisor. And what's going to be interesting and probably complicating the whole issue in these cases would be the superimposition of other causes. You have the fall of crude price, oil price, LNG prices. And finally, when we talk about force majeure and frustration, there must be a causative link between the failure to perform, inability to perform, and the trigger event for the non-performance. So Malaysia, I mean, that's quite clear. We are, a key active country that produces and exports oil. We are central to trade. We have not seen a recent decision on force majeure or frustration, but we have some persuasive and instructive cases coming out of India. Our frustration provisions are premised on very perimeter, very similar provisions of India. And there is one that has come to my attention recently. It's the Mumbai court that talks about trade in the context of COVID in April 2020. And in that situation, there was a contract for the sale and delivery of steel from South Korea to India. Contract shipment was put on board the ship. It arrived in India, but there was no acceptance of delivery. And the party who was supposed to make payment rushed to court. to suggest that it be relieved of the obligation to make payment and to restrain the payment call on a letter of credit. And the Indian court held, the High Court held, that it was not sufficient to mount a case either on force majeure or frustration. The hardship of performance did not excuse performance. In this case, they held that the lockdown, and India went through a lockdown, was temporary, and it did not excuse a payment of performance for payment. So we have here a situation where, look, just the lack of funds itself is not often accepted as a force majeure event. So if I just stay on just on the shipping aspect, we're going to see a whole suite of disputes that may come about because of unsafe port warranties or safe port warranties, deviation, delay in delivery because you've had to call it another place, quarantines at ports, and all of those are contract-based, and all of those international contracts are likely to have international arbitration clauses in them. So we are going to see quite a bit of arbitration activity. Of course, parallel with the downturn of the economy is going to be a surge in insolvency litigation. And you probably would see restructuring and judicial management orders being made. And with that could be restraining orders and moratoriums. Now, what exact impact those orders have on international arbitration, cross-border international, would be very interesting. And that makes for a lot of issues in arbitration.
Absolutely. I think that's very interesting because also very much shipping specific related issues as well. Liang Bing, I'm turning to you. Any thoughts from the construction end?
Yeah, of course, definitely. Yeah, you know, due to this force majeure that comes about because of the COVID situation, right? Yeah, most building contracts will be affected, right? And you know, most definitely it will definitely arise, and obviously you foresee more cases that will try to exempt themselves from this force majeure or frustration doctrine, in the construction industry, right? Now, the such contracts will you know, in building contracts, right? Yeah, the obviously, because they cannot perform the works, right? Then they will really say that it's a force majeure issue, right? And without a pandemic, right, extension of time dispute is already frequently happening, right? And the force majeure, what more in the pandemic? The pandemic will impinge on inability to work out on the project as well as to secure manpower from other countries because they have imposed lockdown and restrictions. So, so obviously we'll foresee more cases arising out of this force majeure in the construction industry, and particularly in engineering and infrastructure project with international players. Now, such contracts will inevitably have extension of time clauses with huge LD impossible for delay. Now, force majeure is usually a delaying event. Without pandemic, extension of time disputes is already frequently happening. What more with pandemic, right? The pandemic will impinges on ability to work on the project as well as to secure manpower from other countries, because they have imposed lockdown and restriction on their borders, and also financial difficulties caused by pandemic. So what happened is, I foresee there will be unique cases that will arise out of this pandemic and its effect, right? And definitely you'll foresee more cases that will arise from force majeure or frustration doctrine, because of this COVID-19, in the sense that they are unable to perform work, and therefore they will invoke the force majeure events to get an extension of time, or even to get out of contract.
Okay. Following from that, Lambing, you've mentioned the relief sometimes the parties might seek, particularly in the construction industry because of the COVID issue. This leads me to think about the COVID Act that Singapore has drawn up, which Malaysia doesn't have one at this point. So what the Singapore COVID Act does is essentially offer Singapore parties temporary relief from legal action for inability to perform certain contractual obligations. Obviously, you will be very familiar with it as well. But what I noticed in the Act is that it appears to only apply to domestic arbitration in Singapore. I would like to ask this question, Lambing, perhaps for Malaysian users who have international cases involving a Singaporean counterparty. What does this relief in this Act mean for existing cross-border contracts and international arbitration involving a Singapore party? What's the effect of it?
Well, essentially, construction contracts in Malaysia will get relief from the COVID-19 Act, right? In the sense that they will not be able to enforce.
Section keeps dropping.
Yeah, but now for the construction contract, no liability for delay and breach of contract, unless and they can actually serve a notice, right? Now essentially the COVID-19 will affect the sorry Angela, can you move on to another question? But there's something that's bugging me now.
Oh yeah, no problem. I can direct it to Boon Leong actually related to this question. You mentioned enforcement issues cropping up as well during this time.
Right.
Bearing in mind the Singapore COVID Act granting relief to Singapore parties in a contract. Let's say, but it excludes international arbitration matters. So my question to you is, if a Malaysian company has already obtained an award against the Singapore party, can it apply then to enforce the award during the moratorium period, which I understand at this point is until October?
Yes, the moratorium is for 6 months until extended, and you are correct, it should expire sometime in October. And if you were to look at the plain language of Section 5, I think it's Section 5(3)(n) that deals with awards, you will see that what the legislature has done was to deliberately caveat arbitration awards to awards which have been awarded pursuant to the Arbitration Act in Singapore, which of course deals only with domestic arbitration. So on plain language, any Malaysian who gets an award in Singapore, and if that Malaysian, of course, had participated or appeared in that arbitration as a Malaysian party, that would, of course, make it international, and in which case the COVID-19 Temporary Measures Act would not basically apply to prevent enforcement in that sense. But then again, it's really not that bad because, I mean, like, quite apart from it being temporary in terms of the 6 months period, one will have to understand that the reliefs made available under this act is only in relation to contracts made before, I think it's the 25th of March, and in relation to obligations which were contractually obliged to be performed after the 1st of February. Now, there's a lot of hoops to jump through, and I really do not expect there to be a huge number of contracts that basically fall into that category. And certainly, it will be clear that if any party were to enter into a contract today, they would probably not be able to avail themselves to the reliefs that is found in sections 5, 6, and 7 of the COVID-19 Temporary Measures Act.
Okay. Lambing, anything to add?
Angela, perhaps I could just come back to the point that you were asking about whether you foresee more cases from force majeure or frustration doctrine now. Now, certainly in the building and construction industry, you will see that there's going to be more of that. Yeah? Because you know, in the building and construction industry, there's always a standard clause on extensions of time, a delaying factor due to the force majeure issue, and clearly, yeah, this COVID-19 situation has brought about a force majeure situation, right? In respect of which, there are some reliefs in most building contracts, yeah, to give an extension of time, right? And but in particularly in Singapore, right, there is this COVID-19 Temporary Measures Act, yeah, which relieved performance for a scheduled contract, and the construction contracts and the supply contracts, yeah, as defined under the Building and Construction Industry Security of Payment Act, yeah, will definitely kick in as one of the thing that that applies, right? Yeah, and they offer some temporary relief that during the relief period of 6 months, right, you cannot take action for non-performance of that building contract. Yeah.
Yep.
So in Singapore, you do have that relief from that, right? But in Malaysia, yeah, where I don't know whether there's any such equivalent provision, right? You will definitely see a jump in the use of force majeure clauses to get extension of time, right? And in Singapore, although it is stipulated that you are entitled to extension of time for a 6 months relief period, right? There are other issues that can come about due to this extension of time. Right? For example, if there are lockdowns in other countries and the contractor has to secure his manpower from the other countries which experience lockdown after the relief period in Singapore has lapsed. So are the employer going to give you extensions of time for beyond the period of the relief that is granted in under the Singapore Act, for example? So no, there will certainly be issues coming out from there, right? And in Malaysia, where there's no unless there's a provision for such acts, right, then certainly people will use this force majeure to get extensions of time and to relieve themselves from performance of contract, especially in the building and construction industry.
So it sounds like it's merely a holding over period that the Singapore Act is giving, but in Malaysia they don't have something similar. So I think we're still on the same page where we're seeing a lot of disputes coming out anyway involving non-performance of obligations. So this
Angela, may I just just ask a question flowing from what Boon Leong has mentioned about the many hoops to jump through? Would it be right for, say, a Malaysian party who's entering into an international arbitration in Singapore to check the first check post would be, has the Section 9 notice even been issued against that counterparty? If it hasn't, then really there is no question of the party, the Singapore party, bringing up the moratorium against the Malaysian party subsequently. Am I right in thinking that way? As that being one of the hoops?
That is certainly one of the hoops, because that's one of the three requirements in order to avail yourself to the reliefs in sections 5, 6, and 7. And there is another twist to it, Sitpa, quite apart from the fact that you are correct, in the sense that that will be a good test. If the notice under 5 has not been issued, then of course one will say that you're not entitled because that's a precondition. Now, the other side of the coin is that there is a possible argument that if you were to commit the acts that is in 5 subsection 3, which is prohibited by law, you could run the risk of a criminal offense. Okay, now I really don't think that it should be, personally, it should be one of strict liability. Of course, the language could be clearer on that, but that is also something to bear in mind, in the sense that if you were to commit any of those things, you could be opening and exposing yourself to criminal prosecution in that sense.
Interesting.
Yeah, I think we are also slowly seeing parties who are raising this moratorium in our cases as well. So I think we'll wait and see. Not many, handful, but I think we are expecting to see a lot more in the coming months, perhaps.
Which is why I think, sorry, Angela, which is why I think that the safest course of action to take, if basically one is unhappy with anybody's attempt to claim protection under Section 5, 6, or 7, would be, I suppose, to invoke the assessor procedures that's made available. That would be the safest way for you to test the entitlement of the counterparty to relief.
That's an interesting way to go about it as well. Okay, thank you. Moving on to our next question. I would be directing it to Sipa actually. So we know from the discussion earlier, a lot of the disputes arising during this time would inevitably involve delay, non-payment of contractual price, or any other non-performance of obligations under the contract. While some of them can be complex, but some of them can be quite straightforward, or straight up non-payment of invoice for delivery of goods, for example. So as we anticipate these disputes, as a counsel, would you see your approach to dealing with this dispute be different now? Would counsel be more inclined to use tools like the early dismissal, for example, to have the arbitration run more quickly and finish it faster to reduce costs, for example? Is there more of this kind of considerations in the mind of the counsel right now?
Okay, Angela, yeah, that's absolutely pertinent. So putting it in context, we are in a stage where millions of jobs have been lost and will be lost. Businesses turnover has severely been impacted. So, and dispute resolution costs are really, frankly, non-essential costs. So the question, the fall of every party who's a litigant, and finally it's a litigant who has to come to the lawyer, is, am I wasting good money chasing bad money? And that was one of Yan Bing's questions earlier on, as to what is the consideration really. And if finally they decide, well, it's worth it, then what I foresee, and actually I've been seeing that from the beginning of the year, before the rest of the world saw COVID, I think China had experienced it. And as I was sitting as arbitrator, I found that there were far more applications for partial awards to be issued. And so what counsel are tending to do is not line up a huge, big fight, a big battle at the end of the day with a month-long litigation with extensive discovery. What they're going to do, I think, is look for bite-sized victory and then leverage on those victories in a partial award, perhaps, to get a settlement, or indeed maybe waive the rest of the claim, because you have to decide at what point you cut your losses and take what you have. So yes, you're right. I think we'll be seeing more partial award applications. You'll be seeing more early determination, dismissal applications based on the lack of merit of the defense or the claim. I also think we are going to see far more interim reliefs being sought, whether through your emergency arbitrator or in your tribunal that has been fully constituted, which is to preserve the cash flow position. It's become sacred. Cash flow is, and they want to preserve it as much as possible, either to not call, have someone be restrained from calling on a performance bond, or to preserve the subject matter of the dispute. It could be bunker that is disputed as to the ownership in these trying times, or it could be indeed one of the things we spoke about earlier, the impact of a cross-border moratorium or restraining order on the parties. But that would be a preliminary determination. I think we'll see more of that, and that could then move into a med sort of hybrid, or indeed bring close to the arbitration, or it might be fought out. But I think inevitably that would be one of the stages we will go through.
Oh, interesting. That we have a question from one of the participants who mentioned that who mentioned as well the applicability of met-up dispute resolution clauses, for example, for complex multi-party commercial contracts. The participant is asking that perhaps international arbitration will benefit from this whole situation because smaller disputes will get resolved by mediation, and therefore it leaves the tribunals with time to adjudicate complex or bigger cases. Is that something you agree with, Sipa, sitting as an arbitrator yourself?
Yes, I can foresee that happening. Smaller claims, it may not be worth throwing in what little reserves they have on it. It might be worth just mediating it, getting it settled in whichever form. And then the most significant ones, and those would be perhaps with parties with deeper pockets, might be worth pursuing to the full end. Yes, it's certainly one option. that we'll see unfolded.
Okay, so it seems like parties might, because of cost constraint issues, will consider either bifurcating the issues or just solely focusing on the crux of what they're arguing about, just to keep the arbitration short. So I'm giving you the difficult task right now. I'm looking at Rule 29.1 of the SIAC rules, which is the early dismissal provision. There are two limbs to it. One is manifestly without legal merit, and one is manifestly outside of the jurisdiction of the tribunal. Do you, as a counsel, are you able to think of any COVID-related argument or basis where a party can utilize in order to fulfill either of these limbs to get an early dismissal of a claim or defense?
Well, I'm a firm believer of minimum effort. I suppose that if you have the facts basically to satisfy any of those events in 5.3, that will be enough, I think, to get over the manifestly test or threshold in Order 29. And I think that that will be a convenient answer for me. If anybody will fall within a 5.3, any of those events, and somebody's attempting to sue them on that, well, there you go. You probably will have a quick answer to that. And but beyond that, it's difficult to say because the current Order 29 in itself already recognizes the fact that if the case is from a legal viewpoint, cause of action, jurisdiction, if it's that clear, then it will be out. What, of course, is not completely agreed upon is whether cases or disputes with factual disagreements can be brought under Rule 29. You have some of the stakeholders taking the view that no, but I personally would like to take the view that it's not absolute in the sense that there will be cases where even the facts are so abundantly clear, or to quote the Trans-Global Jordan case, it's so clear and obvious that you can establish that with relative ease and dispatch. So I think that because of the test that's required in Rule 29.1, COVID impact on most commercial activities, I believe, will be factual. And if my take on that is correct, in the sense that COVID gives rise more to factual issues rather than legal issues, like the force majeure or frustration that Sitpa has just talked about, then Order 29.1 probably won't feature as much as we would like to help resolve disputes in that sense.
That makes perhaps Sitpa's suggestion of a partial award route to be more desirable in that sense then, instead of limiting to the legal issue requirement under Rule 29. That could be something the parties can think of.
Yes, exactly, because the Rule 29 route also has a constraint on time. You have to have the award out in 60 days, and sometimes if you need witnesses to come in, it might require a fuller determination, as Boon Yong correctly pointed out, and therefore a partial award may seem to be you can't, one size does not fit all, and each case will depend, and the council will definitely take these things into account. They have many things in their toolbox.
That's good to know. Saktan, there is a question from the floor. I thought I would like to just direct it to you, and perhaps the rest of the panel can chime in as well. This is in relation to agreements that contain both mediation and arbitration clauses. I suppose what the participant probably meant is a multi-tier dispute resolution clause, and they asked, at what point can mediation end and arbitration start when the former has failed? So I suppose it's a question about strategic timing, perhaps with cost constraint in mind. What are when should mediation be considered as failed, and when should one properly commence an arbitration?
It's a multi-tiered question. Okay, first of all, a lot of mediation clauses that you see in contracts actually have a limited time frame because of the second layer to that question, which is that mediation requires a consensual resolution of the dispute. And if there's no consensual resolution, then the mediation process fails. So parties generally in high-value contracts do not want to have an open-ended mediation process. So you'll have typically 60 days or 90 days, after which parties will then proceed to arbitration. Because arbitration is not consensually, it is not dependent on a consensual resolution. The parties then will have to leave the dispute in the hands of an arbitrator who decide one way or the other. So on that score, when parties do have a mediation or multi-tiered resolution process, they generally, for high-value contracts anyway, have a limited time frame and timeline, because they do want to have certainty as to when you then need to have an enforced dispute resolution process. So the question actually seldom arises in the terms of basically high-value international contracts anyway.
Is that the case because they are usually very specifically provided for?
They are specifically provided for generally, and nobody who invests, let's say, 200 million USD in an international contract will want to leave it implied that the dispute resolution process leading to arbitration has failed, because it's not prudent, and no lawyer will actually leave that open anyway. And I personally never seen that in any contract.
Any views from the rest of the panelists?
My personal view, based on what I have come across, is that mediation probably is an arena where the talents and the quality of the mediator is really, really critical, because not only has he got to get the parties in the right frame of mind at the outset, but in a perfect situation, even if that mediator concludes that nothing can be done at that point in time, he would not have caused the parties to have diverged more than what they were at when they first approached him. And the other thing, of course, is that the issues which you have raised as to when is it time to call a stop to it, or when do we continue, you will come across many mediators, and as is usually the case, one may be critical with some for being overly aggressive, overly pedantic, overly aggressive in trying to get a deal done. And you will also get those on the other side of the fence where, you know, they didn't really do much. But you do need a very good mediator. And in many ways, I do find myself as counsel to be pretty much in the hands of the mediator, and hoping that he would make the right call. And as counsel, when I believe that the call that he is going to make is actually a good one given the circumstances, I can but support that call. But it is essentially the mediator who can give the conviction to the parties in negotiations that, well, they've done their best, and both sides believe that they have accommodated to where they believe is fair, and live to either take it out through arbitration, or maybe happily there will be another day where they can go through another mediation and have it resolved amicably, which has happened. So in that sense, I hope to have in some way answered the question when do we call it, when do we stop it, when do we push it? It's not something that as counsel we would determine that based on our performance or our thoughts on the case. In fact, we shouldn't bring the merits of the thoughts about merits of the case into the proceedings, because that has a tendency of really messing the entire process up.
I see.
Yes, I absolutely agree. If I can weigh in on that, the best mediator is somebody with soft hands, but a very hard backbone. From my personal experience, there are many situations in which counsel does walk into a mediation room with a viewpoint as being an advocate, and they will push the position so hard that there can be no compromise whatsoever, and everybody walks out unhappy. And for that reason, in most commercial contracts, we will always advise for a limited time frame for mediation, because from my experience, the people who tend to defeat the mediation process are the advocates themselves.
There's a follow-up question from this discussion, actually. The question is, to what extent are parties at liberty to refuse mediation and proceed directly to arbitration given the consensual nature of mediation? Can a party who intends to oppose arbitration raise the argument that the arbitration is now premature because they did not go for mediation? Any thoughts from anyone?
Well, I can have a stab at that. I think if it's part of the tiered arbitration agreement that anticipates that parties will, as a precursor to arbitration, make an attempt at mediation, I think it is best to always give that a run. Otherwise, you might fall foul of your arbitration being premature. And for me, as a rule of thumb, I would attempt it. And if at some point in time, if it has failed and if there's no objective timeline when I should move on to the next stage, but I have made an attempt at it and it has failed for whichever number of reasons that it has failed, then I move on to the next. But I must show that best efforts, good faith has been put into play in honoring that clause and that obligation to have 2 tiers in my dispute resolution.
Any other thoughts?
Yes.
Yeah,
Absolutely. I agree.
You have to look at the provision of the clause to see whether it's mandatory or it's not mandatory. Right? So if it is mandatory, then you have to actually go through that process before you can go for arbitration. And so it very much depends on how the clause is being drafted.
Thank you, Liang Bing. I suppose we do have a little bit of time. So let me throw in this question for our Malaysian lawyers. Now that the courts have reopened and the Malaysian Court of Appeal has had their first live hearing broadcast back in April, I've heard many good things about the local judges' adaptability and how smooth the online hearings were. But of course, virtual hearing is not something new in international arbitration. As Taksan mentioned earlier, we've started this game much earlier, and it's something that international arbitration do offer. For the Malaysian lawyers, at least, what are your views about the courts catching up to technology? Does that diminish the advantages of international arbitration? Are the courts getting back the cases? Any thoughts?
Chitpa, you take the lead on that.
Okay, well, it's wonderful to see the Malaysian courts bridge the technology gap and maintain our principle of open justice system by broadcast and allowing access to justice even during the period of the movement control order. So that was very, very heartening to see. But whether that diminishes the role of arbitration, absolutely not. And really a few points on that. Simply because arbitrators have been doing it far longer, having remote hearings for that much longer. Therefore, they're far more confident and comfortable with that. Secondly, also because the institutional rules are far more flexible in terms of the manner in which hearings can be held, and the arbitrator is master of his own procedure to that extent. So there are no impediments that the courts now have. They have rules of court and statutes that talk about a physical venue for hearing and sitting. Unless it's consensually done, there are serious problems or serious hindrances to having it remote. There's also the arbitrator's general level of comfort through years of doing this, to have witness testimony recorded through a video conferencing. They are far more comfortable with assessing character and independence and credibility, because they don't have rules of evidence that constrain them so much, and on rules of taking of oath and so on and so forth. So they're quite happy and content to, at the end of the day, weigh all the circumstances and decide the quality of evidence. The courts, however, have been a bit more rigid on that score, and it will take some time before they depart from the traditional view of taking oath and coming to court. I must see you, I must hear you in person and assess your demeanor, which I think we have moved away from a little bit more in international arbitration. But there is a place for both, for arbitration and litigation, and you cannot take away anything from either of them, and I don't think the technology is going to make that difference. Taksan, what do you think?
Absolutely, I agree with Sipa. Well, one of the encouraging things I think Sipa and I would have noted is that the judges have been very willing to accommodate when parties want to do a video conference or a hearing by video conference. One of the issues that we have faced is that when parties do not, or one of the parties do not consent, is that the judges have no power under statute to compel a hearing by video conference. So it has to be done with unanimous consent. And in multi-party litigation, it may be difficult. And I've seen such difficulty where the judge asks, why can't we do it this way? And just one party, all I need is one party to say no, and that's it. And then everybody has to come together. So I think there is talk locally that they may need to introduce legislation to just give the judge that power to compel and to make the necessary orders so that hearings can be conducted in a way that's actually safe for everyone.
Has anyone made the inherent jurisdiction argument, inherent power argument yet?
No.
But I do have an anecdote
I don't
to share.
think we can go that far.
I do.
Rules of court and our Evidence Act do not admit of that kind of implied power.
I see. Boon Leong has something, an anecdote.
Yeah, I have an anecdote to share in the sense that it's something for innovative Malaysia and an indication of how willing the Malaysian courts may be prepared to dive into this virtual hearing, because it's a very simple hearing, and recently. And the arrangement by agreement was that it was supposed to be conducted through a virtual hearing. But much closer to the date of the hearing, of course, things happened, not only in Malaysia, of course. The virtual hearing equipment didn't quite work. And instead of basically going back to a physical hearing, what the court suggested was that we have an email hearing, a hearing by email. So, it's still virtual nonetheless. Sans the visuals, okay? But that goes to show that I think that in the terms of the software, the court, I think, is prepared to embrace this necessary and I think unavoidable move to online. But certainly, I think Malaysia, like everyone else, we still have got work to do on the hardware. But since we are at the cusp of the 5G age, I think it bodes well for all of us.
Yes, and I think Boon Leong, Sipa, and Tammy will agree with me that that when it comes to arbitration, there is a lot more flexibility for the arbitrator, because he's a master of his own procedure, and he's a master of the facts anyway. So if he decides he wants to have an online hearing, that's it. Whereas the judge does not have that kind of leeway. So when it comes to court proceedings, the judge will be open to tactical maneuvers by counsel if they feel that they want to delay proceedings or to force the other party's hand. Whereas with the arbitrator, especially with the in Malaysia, the repeal of Section 42 of the Arbitration Act, the scope for parties to take tactical advantage of proceedings, especially in this kind of environment, is much less. So yes, I do see a lot more latitude for international arbitration. And there's a greater comfort level unless the arbitrator is guilty of misconduct. There is a lot of room for us to explore how we can then develop the avenues for international arbitration.
Sounds like international arbitration should still lead the way in terms of finding creative and innovative way to conduct a hearing and get the disputes out of the way. That's all the questions we have for today. Anyone else with last comments?
So I thought, Angela, just now when you were asking me about the question whether do we foresee more cases arising from force majeure or frustration, I was a little bit having some difficulty, and I got distracted a little bit. So I didn't really answer the question earlier. Could I just take a quick moment just to answer the question?
Of course.
Now, of course, in the building industry, right? We will definitely see more cases arising out of force majeure and frustration, simply because it is invariably in most building contracts that there is a force majeure clause governing extensions of time, right? So it will most definitely be invoked due to this pandemic, because pandemic is actually a force majeure. And the question that will invariably arise out of this pandemic will be, how much extension of time will I get? So, and if you are looking at infrastructure matters where there are huge LDs involved, certainly, you will not see the end of it simply because the pandemic ends. The effect will go on because they have been affected, and in Singapore, although you get temporary reliefs as a scheduled contract, because construction contract is one of the scheduled contracts, right?
Yes.
But even after the relief period is over, there will be issues about delay because perhaps India or some other country is having a lockdown and the contractor is unable to get manpower from those countries, right? Which affects their works after the relief period. Right? So although the Act here in Singapore gives release for the period of time and no LD can be imposable on the contractors during this time, but the contractor will invariably ask for more time. And there may be things to support it. For example, if it secures the workers and manpower from India, and India is having a lockdown after the relief period here, the employer is not going to grant you more than what you are required. But under the contract, you may be able to force a situation where you get more extension of time. Right? So, although and also the interplay of this temporary relief from legal action in Singapore, right? So it is clear that construction contracts, pursuant to the definition of the Building and Construction Security of Payment Act, right? It's construction work in Singapore. Right? What happens if there is a construction work in Malaysia done by Singaporean and out of which a Singapore party gives a performance bond? Under our reliefs here, the performance bond cannot be called because the Act says so. But can a Malaysian party, construction work in Malaysia, make a call on the bond in Singapore? I'm sure it did. I'm sure they are able to, because It is not construction work in Malaysia, in Singapore to begin with. It doesn't fall under the definition of the COVID-19 Temporary Measures Act. It is not a construction contract within the meaning of the act. Right? So if somebody made a call on the bond, a Malaysian contract, it calls on the bond for a provider in Singapore, I don't think the act grants any relief to this call. Therefore, these cross-border issues may arise. And although call on the bond is protected here in the sense that you cannot make a call, right? But in Malaysia you can, and if there's any arbitration that comes out from it, you can still go on with arbitration.
Right.
Absolutely. Yeah. Absolutely right. And for me, the coronavirus cannot absolve somebody from having entered into a bad bargain, and that is a cautionary tale for any lawyer to anticipate all risks. Now, if risks are not anticipated, and the contract is clear enough, then it will be very difficult to get out of it, simply because somebody caught the flu bug. I mean, I don't mean to trivialize the current situation, but we've been through this before, and a contract is still a contract, and it's arbitrable.
Yes.
That's quite consistent generally. I suppose the consensus is, despite the Release Act in Singapore, a Malaysian party don't have to worry too much because there has been in place many hoops to jump over, as Bruno has put it, I suppose. So I think that concludes our session today. Thank you very much to all the panelists and all the participants for spending your time with us. I hope it was valuable, and I thank my fellow panelists all very heartfelt thanks for your time, and we hope to see the rest of you at our next webinar. Thank you.